Good evening, ladies and gentlemen, and thank you very much for joining us this evening for this launch of the Melbourne Centre for Commercial Law. My name is Matthew Harding, for those who don't know me, and I'm the Dean here at the Melbourne Law School. Can I begin by acknowledging the country on which we're meeting, the unceded country of the Wurundjeri people of the Kulin Nations. I want to pay my respects to their elders past and present. I want to also acknowledge the work of my Indigenous colleagues here at the Melbourne Law School, and I want to welcome any Indigenous colleagues or friends who join us for the event this evening. Not going to speak for very long, you'll be pleased to know, but I do want to say something briefly about this new centre before I introduce our distinguished speaker. This centre has been a long time in the making. It draws together what have been vibrant and important research communities within the Melbourne Law School, each of which has made a very valuable and distinctive contribution to our overall research effort in connection with commercial law, and each of which now, we hope, is strengthened through this coming together and operating as a single research centre. The centre will now bring together expertise across a variety of areas: corporate law, financial regulation, construction law, commercial arbitration, consumer law and tax law. So that's a wide range of academic expertise that now is brought into greater alignment in this centre. Professor Miranda Stewart is our inaugural director of the centre. But of course, this sort of effort is never the work of one person alone. And I want to acknowledge the colleagues who are present here, and actually also those who are not, whose work as associate directors in this centre and as researchers working under its umbrella is so important. That includes Professor Ian Ramsey, Professor Jeannie Patterson, Wayne Jokic, looking around the room, Matthew Bell. We have so many colleagues whose work is of significance in this area and whose work this centre is now going to support. I should also mention Professor Rosemary Langford, who wasn't able to be here, but who of course is a leading voice in the field of corporate law and excuse me, private law more generally. In a minute I'll call on Miranda to say a few more words about the centre and to take you through the format for the evening. I'll say something briefly to that topic now as well. Shortly I'll introduce our guest speaker, the Honourable Chris Maxwell. Chris will speak for 10-15 minutes, I think, and that will be followed by a panel discussion, hence the chairs, with some of the associate directors of this new centre. That's Wayne Jokic, Richard Garnett. Is Richard here? I didn't see Richard earlier. Oh, hi Richard, you're right at the front. Wayne, Richard, Ian Ramsey, and I believe Jeannie Patterson as well. And that panel will be chaired by Miranda. For those who care about such things, the event's being recorded, so there you go, now you know that. Then I'll just introduce Chris Maxwell and then I'll sit down. Well, he needs no introduction to most of you. He recently retired after a very long tenure serving as the President of the Victorian Court of Appeal. He was appointed to that position in 2005 and served there until July this year. Prior to his judicial appointment, Chris had a flourishing practice at the bar, working in a whole range of different areas, and of course has become very well known in particular for his advocacy in respect of rights and civil and political rights and freedoms. Chris is currently a senior fellow at the Melbourne Law School, and he has a close and long association with this law school, teaching for us, contributing to our research culture, and engaging with our students and our colleagues in a variety of ways. Chris said to me when we invited him to give this address that he wasn't the first person that came to his own mind in connection with commercial law, and that maybe we should look for someone else. But I did remind him that he has been thinking and writing on these topics for a few years now, and teaching on them as well. And so we thought that he would have something very interesting to say, even if he didn't agree in the first instance. So nothing more from me now. I'm going to hand over to Chris Maxwell. Thank you very much, Chris.
Thank you very much, Matthew, and good evening, distinguished colleagues and friends. It's a great honour and a special privilege to be asked to launch this centre. As Matthew said, I did demur because those of you who know anything about the Victorian Court of Appeal will know that 2/3 of what we do is criminal appeals. And the longer I was there, the more I became regarded as a specialist in that area, and accordingly the more of my work was on the criminal side. And we really left commercial appeals to people who had some pretensions to being commercial lawyers, though I did for many years act for the tax office, and I did occasionally act for ASIC and the ACCC. So I knew my way around those regulatory frameworks, although that's a long time ago. Having failed to convince Matthew that someone else might be a better pick, I then opened up the invitation and my heart leapt. Phrases jumped out of the page at me and made me think, oh yes, that's a launch I would like to be part of. Now, you probably haven't read the invitation as closely as I have, but let me just remind you of, and I'm keeping a close eye on the clock because Miranda said, short and sharp, please, Chris. These phrases leapt out at me. Quote, build collaboration across research programs. These, of course, are the aims of the centre. Secondly, address common challenges across what's referred to as the broad field of commercial law and business regulation. And thirdly, engage with business, governments, the profession, the courts and regulators. That sounds like a pretty exciting ambition to me. Let me just sum it up. What this centre aims to do is to engender collaboration across disciplines and engagement with relevant sectors of the business and legal community to identify and address common challenges. As I say, that seems to me to be a brilliant idea, absolutely ripe for the fulfilment of its potential. Now, I speak from experience when I say that collaboration and engagement is a pathway, if not the pathway, to improving the way the law operates. Quite unexpectedly, those two conceptions, ideas, themes, collaboration and engagement became, over my 17 years at the Court of Appeal, really my guiding lights. As I say, this was quite unexpected. I went to the Court of Appeal hoping that I could manage my 10 colleagues and learn how to write a judgment, and I thought if I did one or even both of those things, that'd be about enough. But I quickly found that there were reasons for collaboration and engagement. I'm just going to give you a couple of quick examples. We collaborated across criminal justice and we engaged with government to produce what is a world first in simplifying directions for juries. And that was because we harnessed expertise and interest and commitment to improvement, and because this was a consensus across all the participants in the system, government listened and legislated 3 times over 5 years. We also brought the same kind of collaborative effort to bear in forensic evidence. Now, not something you in this audience will have thought much about any more than I had before I went to the Court of Appeal, but it's pretty jolly important. And if there's a risk of miscarriages of justice, it quite often arises when forensic evidence is given more weight than it deserves. So again, by working together, we've improved the quality of forensic evidence in Victoria. And we collaborated across disciplines within the Court of Appeal. I came to the Court of Appeal, as my esteemed colleague Kristen Walker has more recently, as a public lawyer. And I think the criminal lawyers would be the first to say how much they appreciated a public law perspective on criminal law. I'm being slightly facetious. They weren't entirely sure that the public law perspective was what they were looking for, but I think as we look back on the work of the Court of Appeal over the last 10 or 15 years, the amalgam of approaches, the cross-fertilisation on any given bench with a criminal lawyer and a public lawyer and a commercial lawyer produces something better than any of us could have done on our own. And then the other unexpected collaboration and engagement for me was with academia. In a way I'd never felt as a barrister. I felt acutely as an appellate judge. I needed to learn more and I needed to understand the conceptual frameworks within which the individual case questions arose. And it dawned on me belatedly that there was so much to be learnt from the academy. And so Adrian Stone of this law school and Jeff Goldsworthy, now of this law school, and I conducted seminars 3 times a year for 7 years under the label Judges in the Academy. And as I was saying to some of you over drinks, it's mutual learning. The academic goes away having a better sense of the problems as they look from our end of town, and we go away with a sense of intellectual enrichment on which to build our adjudication. The culmination of this engagement, at least for me personally, is the article which Matthew and I have recently published in this law school's journal, or this university's law review. Matthew and I first had a conversation at a seminar here for judges in about 2012, and we immediately, I felt, and I think he felt, we spoke the same language from our different perspectives. So when I had a first go at writing about unconscionability, which is something all of you in this room will be familiar with, I then suggested to Matthew that we might write something together. And so the article is called Private Law, Conscience and Moral Reasoning, the Role of the Judge. The transformation of my early jottings on the topic into the final form, thanks to our collaboration, was for me remarkable. But naturally, we bring different perspectives. Matthew's as an equity scholar, mine as an adjudicator, with some familiarity of the nature of the task which judges confront. And I just want to quote one little passage from the article, because I think it's an example of the kind of cross-cutting issue which a centre like this might well want to grapple with. Quote, "We make an avowedly normative claim. We contend that conscience-based doctrines, unconscionability and equity's doctrine of unconscionability, can and should seek to provoke moral reasoning in business settings. Not in law school classrooms, but certainly there, in business settings. By that means, we argue, these doctrines can contribute to a business culture in which the likelihood of exploitative business practices is reduced. More particularly, we suggest, what a judge says in a judgment about conduct against conscience should be understandable and applicable in the marketplace as a source of tools for ethical conduct." Now, time doesn't permit, much as I would like to develop some of the themes from the article at greater length, but it's bristling with interesting questions. How do lawyers go about dealing with an explicitly moral concept like conduct against conscience? Are we teaching students how to reason morally so they can advise their clients on where the line might be drawn between acceptable and unconscionable conduct? Do judges have the capacity to be moral reasoners? And if they do they know how to facilitate the communicative function of these doctrines? Now, this is a centre which could promote the very kind of discussion and reflection, not just in the judiciary or in the profession, but in commercial law teaching, and then, of course, by engaging with the business community and the regulator, ACCC, which enforces those prohibitions. You read the Hayne Royal Commission report and you get a pretty fair sense that nobody knows there's a rule against unconscionable conduct, let alone understands what it means. Well, given that that's in legislation of the Commonwealth Parliament, that's a bit shocking. And that's where collaborative engagement of the kind this centre is committed to seems to me to have real potential. I want to finish by just mentioning, no, there is one other thing I need to mention. There are big questions beyond unconscionability about what it means to be an ethical commercial lawyer. And the article, which I told somebody I went and checked upstairs in the library this afternoon, is in volume 92 of the Australian Law Journal by Barbara Misha, who is a lecturer at Sydney Business School. And she writes about corporate law practice, legal advice and ethics, full of interesting questions about the tension between personal ethics and professional ethics and how far a legal advisor can and should go when the client's conduct is questionable. I just wanted to end with one idea that crossed my path last week about a common challenge for the different disciplines which this centre will bring together, and it's legislative complexity. Now, you might say that's a pretty dry and dull subject. Well, not necessarily, and in any event, it's absolutely at the heart of what you're teaching and what lawyers are having to advise on and what courts are having to interpret. And Justice Hayne, in his report, said, quote, "The more complicated the law, the harder it is to see unifying principles and purposes." And I was prompted to think about this because of a really interesting article on the Oz Pub Law blog. And I would say, Miranda, don't forget the public lawyers. who've been looking at some of the more complicated pieces of legislation, and yes, it's the Corporations Act and the Income Tax Assessment Act 1936 and the 1997 Act, which keep getting bigger and more impenetrable. And one question they raise, and I'll finish on this, is have we been too prescriptive? Which is a really interesting question for each of the sub-disciplines in this centre. I mean, unconscionability is a lovely example of a broad standard. And some people say, oh, well, I don't know how to comply with it. Well, we argue that's actually quite a good thing. But the other view is businesses need to know exactly what they can and can't do. So it'd be most interesting to hear the reflections from the construction industry or arbitration, the tax office about whether if we're going to try and simplify the law, that's one solution. So on behalf of everyone here and on my own behalf, I have enormous pleasure in launching the centre and wishing Godspeed to the centre and all who sail in her.
Thanks very much indeed, Chris, for doing that. And I think there's a commercial lawyer underneath if we dig deep enough. And now you can re-embrace what you've been hiding for so long. So let me just say a few words before I invite our panel up to join us up here for a little bit of a discussion about the new regulatory agenda, whatever that might evoke for people in the room and people on the panel, and about new developments and challenges that we have in each of our different disciplines of law. So I'm Miranda Stewart. I am the new director of this centre, Melbourne Centre for Commercial Law. I'm really a tax lawyer, so probably I'm pretending to be a commercial lawyer too. But one of the reasons for us putting this centre together is because, speaking for myself at least, we're feeling a little lonely over there in the tax world and feeling like actually an awful lot of the issues that I think about as I go through my own research and engagement with people in the profession and in government and internationally on tax is actually connected across these different areas, that actually I need to know more about corporate governance. I need to understand more about competition and consumer protection. Arbitration is becoming increasingly important in my field and something I know very little about. And construction law seems to me to be kind of at the heart of the economy in this country, perhaps always, and is the biggest program in this law school master's degree as well, for example. And this is an area where we really should be getting more connected. So that is one of the key goals of the centre, is to connect us. I'd just like, before going on, to also to thank the Dean, Matthew, for sort of leading us through this process, which has taken a little while. To also, before going further, to also on my own behalf acknowledge the traditional owners of the land on which we meet, the Wurundjeri people of the Kulin Nation, and to say that actually some of my earliest research more than a decade ago that I'm hoping we might start to reinvigorate, which combined tax and business and corporate aspects, was actually about Indigenous economic development. I was part of a very large, long-running, 10-year funded research project with Marcia Langton, colleagues here in the law school and colleagues elsewhere in the university and in large mining corporations, about the process of constructing a sustainable and ethical and acknowledging country way to do business and engage in commercial activity in this country. So I think that that's something that one of the things we could explore in the centre. So with that, can I bring my panel up to join us here? What we're going to do is raise a few key issues that are happening in our fields. There's a second microphone down there. While people are sitting down, what I will get everyone to do is briefly introduce themselves and their program and centre. aspect of the centre, actually. And before I do that, I will actually show you a little bit more about the centre and the research programs. So as I said, I'm really a tax lawyer. My background, I've been an academic for nearly 25 years now in the US and here in Australia, but I have worked in private practice at Arthur Robinson and Head Oaks as it then was, and before that in government in the tax office. And I think that combination of the regulator, the private practice taxpayers or the profession, the business community and the academia is a key element of this centre. So let me tell you, we've said Centre for Commercial Law writ large, so this is not excluding any areas, but we have 4 primary research programs in the centre: corporate law and financial regulation, consumer law and policy, construction law, commercial arbitration, and tax law and policy. And in particular, I'd like to acknowledge the corporate law. So of course the law school has had for many decades a Centre for Corporate Law. Ian Ramsey kindly agreed to be on the panel, and he'll say a couple of words about that in a minute. But we decided that we wanted to bring these strong fields of research and teaching together in this new centre. And so it's great to be building on that history of the Corporate Law Centre here at the law school. And let me just put up, so you guys are the real life version. I've got photographs behind, you may not have realised. We have a couple of program directors who aren't able to be here, so I just wanted to acknowledge everybody. So for construction law, we have co-directors, Matthew Bell, who I think is somewhere in the audience. Thank you, Matthew, and Wayne Jokic, who's here on the panel. In consumer law and policy, we have Jeannie Patterson, Professor Jeannie Patterson, who's here on the panel, and Julie Clark as a co-director of the research program. Professor Rosemary Langford unfortunately could not be here this evening. Ian's kindly standing in. Rosemary is of course directing the corporate law program, and Richard Garnett here for commercial arbitration. And we should also give honorary mention to Andrew Godwin, who not strictly speaking with us at the moment because he is full-time trying to simplify the financial services legislation at the Australian Law Reform Commission, the ultimate engagement in practice, I guess. So this is who we are, but we will, of course, not forget the public lawyers. We will not forget the obligations group, equity, trusts and contract commercial law, very strong connections there at the school. And we may not even forget the criminal lawyers. I did sit on the advisory committee to the task force on the black economy, which brought in a lot of criminal aspects of tax, construction, consumer protection, and corporations law as well. So with that, I might just take us back to our front page. Let me start the panel. And look, I hope that we'll have a little bit of time for questions from the floor. And we're also, I think, I speak for all of us, we're very interested to hear what you would like to see from a centre like this. And suggestions you might have. I wanted to welcome as well, I think we have a couple of members of the Law School Foundation Board in the audience, and thank you so much for joining us. So let me begin. Thank you, Wayne. So Wayne wins the prize for having you can't see from at the back, but like the most awesome shoes at the law school at the moment. So that's great. We're really delighted to have Wayne able to join us today. Wayne's been doing a lot of intensive teaching, so we managed to extricate him from that as Associate Director of our Construction Law program. And I think I said already, but Construction Law, I think, is the single largest specialist program in the Melbourne Law Masters. There's a really huge number of students coming, not just out of law, but also engineering and accounting, other disciplines who are working in the field. What's at top of my mind, Wayne, but you might have something different at top of your mind, is that we've just had a state election, as this audience will know, returning the Andrews government, perhaps even with an increased majority. I think the final votes have not yet been counted. But it just seems to me that this state, although it may be this great state in many ways, this state is constantly under construction. I don't know if that's... it just seems that construction, building and infrastructure development is essentially constantly happening in this state and is incredibly important to the economy. So I thought it would be good to ask a construction lawyer first what is going on in the sector and what do you think are the most important sort of recent developments or challenges?
Thank you, Miranda. Thank you superficially for the question, but particularly thank you very much for all the work you've done in setting up the centre.
Have we got you on? We do, yeah.
We've failed the first technical challenge.
No.
So the question really goes to regulation, particularly in terms of the state. So in the election campaign, I think what we saw is that major projects like Suburban Rail Link and like the Melton Hospital and others got a lot of attention, a lot of news. But what's lurking behind that are quite substantial changes to the regulatory regime. So part of that has simply stalled because of the caretaker period. So we're going to see minor amendments to the Building Act and half a dozen other pieces of legislation. But there's a very big scheme of review, and that's going to continue. So that's one aspect. If I could be a bit greedy and say one other thing,
No,
it's
you've got
really,
plenty.
it's
You've got
really
at least
about
3
the
more minutes.
Commonwealth. So at the Commonwealth level, one of the really surprising things for us as construction lawyers came out of the industrial relations changes. Because one sneaky little thing that Senator David Pocock got agreement on was for... I'll speak a little louder. Thank you. So one sneaky thing that David Pocock got agreement from the Prime Minister on was a reaffirmed commitment to deal with something called security of payment legislation, which will mean a lot to a few people here and almost nothing to others. So the basic idea is that there's legislation in all states and territories which gives people in the construction industry a statutory right to make a payment claim. And then if there are disputes, there's a short form adjudication process. That sounds sweet. The problem is, of course, that the legislation is different in every jurisdiction in substantial ways and also in inconsequential ways, like the definition of a business day. So 5 years ago, there was a really substantial review that recommended 86 odd particular changes. The core one, though, was that there should be harmonised legislation or that there should be a Commonwealth Act or some solution like that. So we might see something there, but I've got to confess, as a construction lawyer, I was always suspicious about how this would work because it doesn't seem to me there's an obvious way for the Commonwealth to legislate. They can look at corporations' power, but that doesn't deal with the people at the very bottom of the industry. So one of the things that I'm really enthusiastic about with this centre is the opportunity to look around and see what happens in arbitration, where the states and territories have managed to get around this, or in consumer law, or perhaps most obviously in the Corporations Act. So it's these sorts of challenges I think that we in the construction industry can't deal with alone. And we need to look at these examples and to work closely with colleagues. And so I think it's just a great example of something that's right in the news at the moment, where the collaboration that we'll achieve through this centre is very exciting as a prospect for me. And I hope that we can do something useful for the industry. Thanks, Madam.
Thank you. There you go. You just have to talk loudly and it's fine. Pass it on. So we're just going to introduce a few things for us to consider. That was very efficient, almost too efficient. I'm going to have to come back to you, Wayne, because you've got at least 2 minutes up your sleeve and I need to bring you back to this question of what was the state review. I'm going to do that actually before we pass it on. What was this? I'll use my mic again. You hang on to it. So you said something about under the state law, there's going to be a big review. There's been a big review. So this is why we need to have this event, is because I know nothing about this and now I need to learn.
Thanks, Miranda. Let's be frank, there are obvious problems in the construction industry. You only need to go down to the CBD and see problems with cladding. You need to look at problems with legislation that's simply not being enforced. There are, I think, clear problems to everybody. People here, I'm sure, will know people who've had problems with waterproofing, problems with cladding on buildings that just isn't safe. So there are clear problems both in the legislation and particularly, I think, in the enforcement. So there are some tinkering changes at the moment. Some of you might have heard there's a fund to deal with cladding problems, but beyond that there is a much more substantial 3-stage review. So essentially we've got through stage 1. Stage 2, I think, is where we get to more interesting questions. So they cover things like dispute resolution, which, if I could speak frankly, is a notorious problem in residential building particularly. But further, potentially quite interesting, significant changes like statutory duties of care, which we've seen in New South Wales. So that's one of the bullet points that we've seen for stage 2. And so there's plenty more to come on that topic.
Thanks very much. So I think one of the issues that occurred to me as I was talking to my colleagues and thinking about what these new challenges might be or these cross-cutting issues might be for the centre, dispute resolution is an obvious one, it seems to me. It arises in different legal frameworks in each of our areas. Obviously the courts are always involved, or tribunals, but under a whole array of different settings. And sometimes dispute resolution really doesn't seem to be working, or processes really don't seem to be happening. So that's something that we thought might be worth exploring. Right, I'm going to jump to the other end of the panel here. I think Professor Ian Ramsey may be known to many now, Professor Emeritus, but Ian, I'll leave it to you to briefly introduce yourself, standing in for Rosemary Langford. And I wanted to ask you, what do you see as one or two of those key recent developments in corporate law or corporate governance today?
Thanks very much, Miranda. And I am sorry that Rosemary Langford, who is the Program Director for Corporate Law, cannot be here tonight. Unfortunately, she has a pressing prior commitment in Brisbane that precludes her from being at the launch. So I am a substitute, if you like, from the past, being an emeritus professor. But I should say that it's a great pleasure for the Centre for Corporate Law, that was established in 1996, to, after some decades, merge with other research hubs, research centres, research institutes in the law school, collaborate with them in a way that takes to a new level what we've previously done in terms of collaboration, and form part of this exciting new centre. Perhaps we could say it's a little overdue, but it is wonderful to be here this evening and to form part of this launch. Now, there's much that I could speak about in terms of recent developments in corporate law and corporate governance. If we just think about, for example, ongoing corporate collapses and prosecutions following them that clearly have displayed profound corporate governance failures. We think about ongoing debates about the need for greater diversity among members of boards of directors. We consider also, for example, ongoing debates about remuneration arrangements for some of our chief executive officers, ongoing debates about directors' duties, including very recently the impact of climate change and the extent to which directors need to take into account climate change as part of complying with their duty to exercise reasonable care and diligence. And our keynote speaker mentioned, of course, the Hayne Royal Commission. And some years, of course, we need to remember that report was handed down in February 2019. Several years later, we have ongoing litigation and ongoing consequences, particularly legislative change, litigation, as I'd mentioned, flowing from that very important Royal Commission report that did find significant corporate governance failings among our most important financial institutions. Indeed, as of 30 June this year, our 6 major financial institutions have agreed to pay back, as part of compensation, $3.6 billion to consumers who have suffered loss because of poor financial advice and services that were not provided, even though fees were charged. In the remaining few minutes, let me just touch very briefly on two issues where we in the Centre for Corporate Law, now the new Melbourne Centre for Commercial Law, have conducted corporate governance research, which I think shows opportunities for greater collaboration. First of these is shareholder resolutions, particularly ESG or environmental, social and governance resolutions. A colleague and I have recently completed and continuing research in this area showing that these resolutions, which a few years ago we really wouldn't have heard of, are growing in importance and impact. In other words, resolutions put forward by shareholders, typically opposed by the board of directors, and yet they want the company to address, for example, the impact of climate change on the company by way of perhaps increased disclosure. Now, because these resolutions are typically opposed by the board of directors, they usually don't get majority support from other shareholders. But our research shows several key developments in recent years. Companies are confronting more of these. In addition, shareholder support is growing. In 2020, for the first time, a major listed company in Australia had a shareholder resolution passed by majority vote in opposition to the board of directors, which opposed this shareholder resolution. That was Woodside Petroleum, and the resolution wanted the board of directors to introduce targets to comply with the Paris Agreement. In 2021, AGL Limited had a similar resolution passed by its shareholders by majority vote, again in opposition by the board of directors. Thirdly, what we also see with these resolutions is that even if sometimes they fail, the shareholders are able to partly negotiate with the board of directors to see some movement in terms of how the company addresses climate change. And finally, clearly developments we see here in Australia on these matters are international developments. Here, on this important issue of how companies are addressing climate change, there's clearly scope for collaboration with colleagues in the new centre. And of course, this issue, important issue of climate change and how companies are addressing it, and in particular how corporate law can play a role here and corporate governance, is just part of a broader landscape of regulators, as we know, paying increasing attention to companies' disclosure of how the companies are addressing climate change, increasing litigation against companies in terms of climate change, and also, of course, we're seeing executives have as part of their remuneration packages on an increasing basis incentive components based on matters such as sustainability and climate change. Very briefly, the second issue that we have done extensive research on is enforcement. Again, a matter that our keynote speaker mentioned. It's topical just to spend a moment or two on this because it was only on November 3rd that ASIC announced its enforcement priorities for 2023. It announced 12 enforcement priorities. And why I mention this is it's the very first time in the history of ASIC or its predecessors where the regulator has said these are our enforcement priorities for the forthcoming year. And that's important because we know where the regulator will spend its enforcement dollars. And those 12 priorities included things such as protecting vulnerable consumers against predatory lending. They included other matters such as combating investment scams, also sustainable financing and the issue of greenwashing. Also, perhaps unsurprisingly, corporate governance failures and directors' duties failures. I'll just conclude with a couple of brief comments. Firstly, it's unsurprising that we see ASIC set as a priority for next year, cryptocurrency scams. As of June this year, in the previous 2 years, ASIC had received well over 2,000 complaints about cryptocurrency scams. Last year, Australians lost more than 700 million to investment scams. And ASIC tells us that the biggest driver of those at the moment is cryptocurrency and crypto ASIC scams. In relation to sustainability financing and greenwashing, it's interesting that only a week ago, ASIC brought its first case against a company alleging greenwashing by this company. It was an energy producing company where the claim was that the company was saying that its electricity was in fact carbon neutral, and the allegation was that that was not a correct, not a true statement. And finally, unsurprising that ASIC says that a focus next year is on corporate governance and directors' failures. The research that we've done here tells us that over many years, ASIC has been a very prominent plaintiff on directors' duties cases. More particularly when we look at the important duty of care, ASIC is the most active litigant. Much more active than when you look at all the private plaintiff cases. And our research tells us that not only is ASIC the most prominent litigant in this area, and therefore changing governance standards in some of these cases when it succeeds before the courts, but it also has a very high success rate. So in summary, next year we can expect much more debate, much more discussion about these two issues, climate change and the impact of corporate law and other parts of the law on how companies address climate change and sustainability issues, but also much attention, understandably, on enforcement issues. Thanks, Miranda.
Thanks a lot, Ian. That's really interesting. And we'll come back to transparency and reporting. It's a key issue in tax and probably in other areas as well. But I thought you might be interested to know that some of you might have heard of Piketty and his books on inequality and capital. So he traces the history of the individual tax rate through the 20th century in many countries between 60 to 90% after World War II, the top marginal rate. There is some evidence, although it's not clear about the causal link, that high tax rate performed a regulatory function. It performed a regulatory function controlling executive remuneration. Because why would you pay your executives more if it's all just going to be taxed away? It probably also, I think, played a key role in financial innovation that led to the remuneration of executives in a whole array of different forms of stock options, bonus shares, deferred compensation and so on that got around that personal tax rate at the top of 60 to 90%. But maybe we should be looking at tax solutions to the executive remuneration challenge, among other things. So let me go on in our panel. I'll take you on a journey still through different research program areas. So I wanted to turn to Richard Garnett, who recently is our Director on Commercial Arbitration Matters and recently delivered, some of you may know, the 2022 International Arbitration Lecture that I think was hosted at Clayton Utz and the Federal Court this year. So is the field. So one of the key issues that we had identified in our discussions was, of course, international influences on different areas of law and policy, regulatory development. Of course, it's always happened, but it seems, at least in my field, to be accelerating and perhaps in others as well. So one of the questions is, I guess, in the field of commercial arbitration, is this a field where international developments are shaping the field, or are there other features at play? So thanks, Richard.
Thank you, Miranda. In many respects, arbitration is a creature of international developments. If you go back to its origins, its medieval origins, it was created almost in response to a national or regional court system which was perceived to be cumbersome and impenetrable for commercial people. Business people felt that the courts were largely reserved for aristocratic people who had large property disputes. And so they thought, why don't we create our own? Why don't we develop our own courts with our own experts who know our custom, who know our trade? And we can appoint them, we can trust them to be knowledgeable in their field, and we can devise rules of procedure which suit and are commercially friendly. So in a sense, when we talk about international developments affecting arbitration, international developments created arbitration, because essentially the earliest form was between city-states within Europe, medieval Europe. Now I mention that because perhaps I'm a bit of an idealist on this, but to a large extent the current status of arbitration, the current picture, owes much to its medieval origins. And I say that in a positive way, because it's free-flowing, party autonomy-oriented and flexible system traces back to that time. Now, what you had subsequent to that was a division, if you like, globally between common law countries who, to be fair, were rather less enthusiastic about this new private continental European device. And so, particularly in countries such as England, there was a sense of putting arbitrators in the, if not in the sin bin, then under strict supervision. We have to keep an eye on them, you know. Can't really be sure that they're dispensing justice in the way that the King's or Queen's courts would do. And so for a long time, and we inherited that tradition as well, as did the United States, arbitrators were largely under quite strict supervision, and their orders could be reviewed almost at the drop of a hat in national courts. Now, of course, this isn't really very commercially friendly, and to a large extent that meant that arbitration was stifled in the common law world. By contrast, in the European civil law world, particularly countries such as France, Italy and Germany, arbitration flourished to a tremendous degree, so much so that in many ways it outshone the courts, particularly in the commercial areas. Now, the next stage was interesting because common lawyers understandably like to think that their legal system is preeminent in the world. Can I tell you that in arbitration, the civil law conquered the common law world? Because basically the entire methodology and logic that was developed in the French and German arbitration systems was essentially adopted in incremental stages in the common law world. And there were some very significant examples of that, where common law judges would come out and basically admit that it is now time to admit that the courts should stay out of the game, that the commercial parties should have the proceeding that they want, with the flexibility, with the streamlined procedure, no discovery, no witnesses. Whatever you want to have, you can have, and it's not for us to intrude. So that's the position we've come to. Series of big decisions. Channel Tunnel was a huge case in England which represented that. Mitsubishi Motors was a huge case in the Supreme Court of the United States that represented that. And we had our own decision, Comandate, which was a decision of the full court of the Federal Court, where Justice Alsop gave a groundbreaking judgment. So we've now come to this point where essentially there's this very interesting global convergence. When I teach arbitration, I often say to my students in the class from many jurisdictions, don't feel afraid when you see Australian statutes in the reading guide. Don't feel afraid when you see Australian court decisions, because the principles are now almost generic. We have come to a point where we have this almost global arbitration law. I'm exaggerating to a degree, but not so much. And this is fascinating because as a practitioner in the field as well, I can draw on precedent from many different countries, not only before arbitrators, but increasingly before the judiciary, who they want to know what's happening in Canada, Singapore, and even in the civil law European countries. So it's a great time for arbitration. And arbitration is expanding dramatically. Whole areas that were once thought to be immune, such as intellectual property, even competition law, are now being gobbled up. Banking and finance is still a bit of an unconquered frontier, but that too will fall, I feel. Insolvency, once again, that was thought to be immune. But it's, I could talk for a long time about this, but it's really to tell you that it's a very exciting area, both academically and practically. And I'm very fortunate to have a legal practice which interfaces with my academic work. So I feel that I can contribute from one to the other quite nicely. So, as I said, happy to take any more specific questions, but really the message to give you is that international developments were there at the beginning of arbitration and they remain dominant and central to its practice now.
Thanks, Richard. To your right with Jeannie. That's really fascinating. And so arbitration, I can tell you, is even reaching into international tax, but it's arbitration between states, of course. But, of course, states have been very reluctant to give up their taxing sovereignty and their ability to make their own national decisions. And we are now starting to see, initially in Europe, so that accords with your narrative, and now more broadly, including Australian bilateral tax treaties, an agreement to a clause in the treaty that would require arbitration if the competent authorities cannot come to an agreement about how to allocate tax jurisdiction. So our last esteemed panellist is Professor Jeannie Patterson, who's one of our Associate Directors for Consumer Law and Policy, with a key focus on consumer protection. And thanks, Jeannie, for joining us today. So you focus, I know, especially on digital technologies in the consumer field as well as others. And so I feel like I have to ask you a question about data, whether you answer it or not is another one. But of course, we're all being affected. I assume most of us are being affected by data leaks of many of our largest and previously most trusted organisations in private health insurance, for example. And is this a business matter? Is this a regulatory matter? How do we think about this sort of thing? But I'll leave it to you to do some comments about data. Thanks, Judy.
Well, thanks, Miranda, and thank you to Miranda and Rosemary particularly, because when they floated the idea of a Melbourne Centre for Commercial Law, I said, consumer protection is not commercial law, but we'd like to be part of it if we could, please. And I guess going to Chris Maxwell's point, consumer protection law, credit protection law, perhaps imposes those moral or ethical limits on the practices of the commercial world. So thank you again for having me and the rest of the consumer team. And in fact, data protection is a good example of why we need this sort of not quite cross-disciplinary, but cross-field gathering. We heard until recently that digital technology meant that privacy was dead, and that young people today don't care about privacy because they use social media. I don't think that's right. Privacy is a fundamental value. It's necessary for human flourishing. It's necessary for freedom of speech. It's necessary for human autonomy. But unfortunately, the recent data breaches have also reminded us that data, the information that's collected about us, impacts on how we interact with society and live our lives, and indeed makes us very vulnerable when it's not protected. So what do we do about that? We could say don't collect data, but that would be ridiculous because, of course, with new technologies, data allows many things to happen in the medical field, financial field, educational field, that benefit all of us and our society. And we might say, well, don't steal data, but of course, no law protects criminals from engaging in criminal activities. And those that steal data are clever people who keep trying and keep trying to find the vulnerabilities in businesses and countries. So what do? Well, we need a combination of responses. There's no one law that's going to fix data. It's a combination. And we can think of it as a journey. We need to think about the laws that govern how data is collected. It's not enough to say don't collect data because there's laws like the corporations law, various know your customer laws, various telecommunications laws, which says companies have to protect data, collect data about their customers to make sure the customers themselves are not engaging or are not victims to crime. So we need to think about what data is collected and how, and then we need to think about the laws that decide how that data is to be stored, what data shouldn't be kept, should be disposed of quite quickly, and when data is kept, how it's kept, things like encrypting data, which clearly the Medicare data was not. And then the kinds of laws we need to hold companies to their promises, to their customers about what's done with data. We've seen the regulator has been very effective in buttressing privacy law by using good old prohibition on misleading conduct to make sure that companies stick to their privacy policies about the kinds of data they would collect and what they do with it. Then we do need to move into the area of criminal law and public law, Chris, to think about the kinds of laws we have to protect our data, but also the kinds of laws that we might make about what companies do in response to data breaches, which will provide the right kinds of incentives against criminal activity and stealing data. So it's a rich field and it requires a variety of areas of law within this centre, and also I would add across the road. And one of the initiatives we haven't mentioned yet of Melbourne Law School is that we have a partnership with the School of Engineering and Information Technology and the School of Science, the Faculty of Science, Faculty of Medicine, Faculty of Education. I'm pointing at where they are on the campus, by the way. Engineering's over there, medicine's over there, science is up there, and education's over there. So all of those faculties have got together and have a centre for AI and digital ethics, which is actually in the engineering building, which means that our students here and our colleagues get to benefit from the insights from all of those different fields when we're thinking about this really tenacious and difficult problems that face us in this modern age, and also the fundamental values like things like privacy as well. So, thanks, Miranda.
Thanks, Jeannie. And yes, of course, that's another collaboration we want to make sure we do, is with our colleagues elsewhere in the university and at other universities around the world. So we've done a bit of a tour of some of the key issues in our different areas. I thought I might say a couple of things about tax. I've managed to interject along the way, being the privilege of the chair of this panel. But a couple of things that are recent developments in taxation at the federal level, and of course we have the Albanese government elected, continuing some of the previous activities, especially in the multinational corporate tax space, continuing a previous regulatory and tax agenda that the previous government had, because it's always good to look for revenue among big people who are overseas, if you can. So governments from both sides of the political spectrum have a strong interest in collecting from large corporates. And as my esteemed colleague Frank O'Loughlin, Principal Fellow with us, who's in the room, said to me, that's where the money is. So that's another reason. But the other thing that is happening internationally under the Albanese government, which has been pushed forward more rapidly, and which is something the previous government really did not do, is a real push towards public transparency and public reporting of data. So we have this real tension, as Jeannie pointed out, between privacy challenges and the need for regulatory oversight and supervision, and the kind of the benefit of sunlight, which has been embraced by ministers at the federal level. A couple of key developments in multinational taxation. Currently, the Commissioner of Tax, of course, has a very large amount of data on the top 100, 200 large multinationals, probably the top 1,000 privately owned groups and companies in this country who are under pretty much constant risk analysis and review. We currently publish publicly, the Commissioner publishes publicly the amount of tax paid by some of these large corporate groups, the amount of revenue, and a few other indicators. So there is a whole bunch of other data collected to support international tax collection around the world called country-by-country reporting, which is a process of governments, multinationals collecting data about the profits and level of activity in every subsidiary in every country in the world in which they operate, and then potentially sharing that data from one country to the other. The Albanese government proposes that country-by-country reporting be made public. At the moment, it's not public. In the European Union, we're seeing public reporting of banks, tax data, and now other corporates as well. So we're following an international trend there. So that's something that's in the mix. The other thing that's in the mix touches even more closely on privacy, some of the privacy issues, and that is the idea of a register of beneficial ownership. So again, some people might have heard of this. It was something flagged a few years ago as a measure to counter financial fraud, cash transactions and money laundering, and also tax enforcement. That is that we trace the ownership of entities all the way up to the ultimate individuals who have some significant level of a stake in it. Europe, again, has led the way in this regulation. We now have a consultation paper released just a week ago. I think the Law Council is considering its response to it at the moment about enacting legislation here. Now, in my view, it's extremely important that we do have governments capable of tracing beneficial ownership to the ultimate owners. The interesting question and the challenging question is whether that should be public. right? So the proposal is for public registers of beneficial ownership where we can identify individuals who have a stake, as we currently do with listed companies with substantial shareholdings. That's the controversial issue. And just to add to the complexity, Europe, of course, has been ahead of the game, as it often is in these regulatory kind of fields. And has had public reporting. The European Court of Justice has just this week ruled that public beneficial ownership registers are against European privacy rules. So we've just had a case on the 22nd of November. What's the date today? That is only 2 days ago, I think, something like that. WM and Sovim, where the Court of Justice rejected the Commission's requirements. It was the country in question is Luxembourg, but the public beneficial ownership register is something that is across Europe, saying that it contravenes Articles 7 and 8 of the Charter of Fundamental Rights of the European Union. This is not the end of public beneficial ownership reporting, I think, but it does mean the Commission has to go back to the drawing board and think about regulation. And there's another case on foot about whether public availability of beneficial ownership violates the right of the freedom to conduct a business or principles of business or commercial secrecy. Okay, so that's a little whirlwind tour of some common issues across our different fields. I wanted to leave a bit of time for questions or comments from the floor. I also wanted to raise one or two little questions for our panel. I don't know if anyone would like to jump in your field. In particular, the questions that Chris raised as our keynote speaker about ethics and conscience, I guess, in the field of commercial law. Certainly in tax, this is something we constantly have to wrestle with, this boundary between acceptable tax planning and what the Commissioner of Tax now calls aggressive tax planning, and then what we would call tax avoidance, and then what the obligation of the professional advisor would be. Does anyone want to make a remark? Is this issue of ethics or how to be a sustainable or ethical commercial lawyer something that is coming up in other fields?
Well, in the arbitration context, there's a very important ethical issue that goes beyond the legal representatives because, of course, the arbitrators themselves have quite strict duties of disclosure. Of course, as I said earlier, one of the great advantages of arbitration is that you can appoint your panel, but that necessarily carries with it the risk that that person may have a relationship which was regarded as too close as to then prejudice the administration of justice. So a big issue at the moment, and following a recent UK Supreme Court decision in Halliburton, which has sort of set everyone running, is the extent of the duty of disclosure. I mean, how much does a prospective arbitrator have to disclose about their past? If they were a counsellor, if they were a barrister, you know, what briefs they took in the last few years, what proximity was the one of the parties to the arbitration to the people that you represented. These things are really quite difficult, and that's a huge ethical issue, which is going to. I'm not sure there is an answer. I think it's just going to be resolved. There's going to be attempts to try and address it incrementally.
Yeah. Anyone else? Oh, Jeannie, and then I'll
just make a comment.
Yeah.
I think it's a really interesting conversation. So I have the delight of teaching a first-year subject, which is actually called AI Ethics and the Law. And often, you know, I either hear ethics is irrelevant to the law or the law is irrelevant to ethics. And I think the thing about ethical thinking, and perhaps Richard has alluded to this, is that ethics doesn't tell us how to act, but it tells us to think how to think about how to act. And I think those sort of questions are redolent in the law as well, but they work together rather than in opposition, in my opinion.
Yeah, no, that's right. So we've got a little bit of time for a couple of questions or comments to any of our panellists, or would anyone like to jump in? I hope we haven't sent them to sleep. Yeah, ready for dinner. We can pass them on. Yeah. Take a microphone, yes.
I guess on data, and the question is, to the colleague, or the consumer law colleague, were you surprised, or are you surprised that the Albanese government hasn't moved quicker to instigate private rights of action for data breaches?
Sorry. We should have more mics, but anyway.
So I'm not surprised that they haven't moved faster, and I think they're right not to move faster to institute private rights of action for data breaches. There is a review, as you will know, of the Privacy Act at the moment. But one of the things about data breaches is we've all heard a lot of yelling about the data breaches. We probably don't quite know what's happened yet. And at the moment, there's very little very little clarity about what is an actionable data breach. It's a fault-based regime. It's not a strict liability regime. So I think the care is very appropriate. And the other thing is I was at a conference in Canberra just last week talking about whether you follow, there's lots of nice questions about whether you follow a GDPR, a European model of individual rights of action, or whether the good old tort of negligence actually can do most of the work. So I personally think they're right to wait.
Thank you. Well, look, given our time, thanks so much to everybody for joining us. Thank you very much to our keynote, Chris Maxwell, for launching, and to the Dean for your leadership and support for this centre, and to all my panellists. We look forward very much to I'm going to use that word again, engaging with you in 2023 at a whole range of events and so on. So probably you're on our newsletter mailing list, because that's how you got here. But please spread the word, and we'll keep you informed. And we really do want to connect with people to help us to work out what are the next research projects and agendas that we can go ahead with. So thanks all very much for coming, and have a great evening.